Welcome back and hello. If you remember last time, we read the Constitution, and when we left off, we had a governmental superstructure imposed upon the states and local government. And the debate that was raging at the time for ratification of the Constitution was, why do we have a president when we fought 8 years to get rid of a king? What happened was, in that debate, a compromise was read and led to the first 10 amendments of the Constitution, which we call the Bill of Rights. The session today will be talking about the amendments and how the amendments guaranteed both individual liberty from the state and also gave a recipe for political opposition to the state that we still have today. On page 19 of your textbook, the amendments of the Constitution, we start with the First Amendment. Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. Again, we're going to take this one phrase at a time. And the first phrase is, the government will not establish an American religion. Again, if you remember back to when we were discussing the difference between nation and state, what did we talk about? We talked about this idea of culture, religion, etc., being the traditional aspects of a nation. The United States does not have these traditional aspects. Instead, we have popular sovereignty, rule of law, and tolerance. The Enlightenment and this questioning of the king's legitimacy brought about a real important necessity of not using religion as a vehicle of compliance. In the first phrase, the establishment, sometimes known as the Establishment Clause, the establishment of religion, of an American religion. So the Founding Fathers in the First Amendment, the first thing that they were talking about comes across and they say, we're not going to use religion as either an instrument of legitimacy or of illegitimacy. Your soul is yours. Your faith is yours. The state is not going to use it. How you exercise your faith. What do you do in order to articulate your certain religion, your certain faith, is another thing that the state is not going to interfere with. So, and again, an example of the practice of religion. So there's not an American religion, and we are not going to judge how a person practices their faith. So again, in a personal example, as many of you know, as many of you are Catholic, right? Catholics, we have, when we go to Mass, we have communion, and communion consists of both wine and bread. First communion is served to kids who are in second grade. Now, can I go to the bar and say, give my second grader a drink? No, of course not. It is under the protection of the free exercise of religion that Catholics are able to perform this practice. Other religions have other practices. Some have polygamy, some have other different practices, and that is protected by the First Amendment. So we don't have an establishment. There's no American church. Again, if you remember last time, we talked about the absence of a religious test. And now we have how you practice your faith is up to your conscience. The rest of the amendment goes into this idea of practicing religious opposition. And this is basically a menu or a recipe to how to form a political opposition to the government. First of all, freedom of speech. So we have freedom of speech. And again, this freedom is misunderstood by a lot of people. Freedom of speech does not mean that I can go and shout at my neighbors at 2 o'clock in the morning. Again, remember, what are we talking about? We are talking about this idea of protection from the state. So freedom of speech does not give me the freedom to basically use racial epithets, to say whatever I want to my neighbors or to my family, to do things, spread hate speech, this kind of thing. It allows me to criticize the government. It allows me and able to form an opposition and articulate that opposition of the government. So again, we have the individual, right? The individual, and it is a shield. This amendment is a shield against the state, right? That's the capital. Yes, I spent a lot of money on graphics for this course. So we have, this is what we call a liberty, a civil liberty. And think of civil liberties as a government do not do list. A government cannot do list. A civil liberty is something that the government precludes itself from acting on. We have the practice of religion, and we have the freedom of speech. So again, these protections of the individual is what creates a political opposition. We have the freedom of the press. Freedom of the press. We have the freedom of assembly. And we have the freedom to petition the government for redress. Okay? So let's use an example. Let's say that I'm a person who is opposed to the President of the United States. So what do? Is I start articulating to my wife and to other people in the family about how I am against the sitting President of the United States. It doesn't matter who that person could be, right? So they tell me, we're really sick and tired of your complaints and of your agenda. Why don't you write a newspaper? Why don't you write a tabloid, right? And so I sit down and I start to write why I hate the U.S. government. Okay, and in that I start going out in the street and I start handing it out. And some people talk to me and they say, oh, I think this is very interesting. Why don't we form a club? Why don't we form a meeting, right? And so I say that's great. And so I start to have this weekly newsletter, and then I start to have a clubs, set up the I Hate the Government Club, and then people pay me dues, I get more resources, and all of a sudden I call for a national convention of the I Hate the Government Club, and we're going to meet in Los Angeles. We all go to meet in Los Angeles, and we assemble, and we elect leaders, and we have a structure, and we have this and that and the other, and before you know it, we have a network of people around the country, and then we turn into either a political party, or we turn into a lobbying group, or we turn into the petition when they boil it all down, and they say, why do you really hate the government? And I say, I really hate the government because I think the capital should be in California and not in Washington, D.C. And so we draw up a petition, and we move the government capital to Sacramento, and boom, all of those actions create a individual opposition to the government and all of those actions are protected by the First Amendment. Again, the First Amendment does not protect individuals versus individuals. Now, you can feel that your neighbor has done something to wrong you, or you may feel that someone at your office is talking in terms that are offensive. But remember, all right, the third element, and we talked about tolerance. But this is, again, against the state. This is against the government. That's the First Amendment. The Second Amendment, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Again, this is the right to bear arms amendment, and this amendment is as equal as any other in the Constitution. Yes, it's controversial. Yes, it has people who are opposed to it and people who are for it. It is part of the Constitution. What does it mean? It means basically that every American, under the protection of the Constitution, has a right to own a weapon, own a gun. It also means that if you're a part of the practice of the regulated militia, that you have a right to own a firearm. The Supreme Court has said that owning a gun is a civil liberty. The government is precluded in many ways to regulate the use and owning of a firearm. It is protected in the Constitution, the Second Amendment. And again, let's remember that you can't pick and choose these things. Now, you can choose to oppose it, and you can choose to politically amend it or erase it, or you can choose to support it. Those are all fine. But to ignore it or to say that it cannot be enforced, that's an error. It must be enforced with all the other civil rights. The Third Amendment, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner prescribed by law. Again, we have the protection of individual property. Again, the Brits were famous for taking property over by the army and having troops live in your house, no compensation. And this was a very, very sensitive issue to the colonists, and also a very sensitive issue to people everywhere. So Americans have a protection against the military taking over their property and just arbitrarily using it. And again, in the era of drug use and COVID-19 and other things of the police and the state and the individual, we have the Fourth Amendment. The Fourth Amendment deals with the right of search and seizure. And again, when we're talking in terms of searches and seizures, the question is reasonableness. What is reasonable? And we don't mean this in the terms of everyday speech, or let's say you really like someone and you say, they're really reasonable. That person gave up his chair for me, and they bought a cup of coffee for me, and then I bought the Danish, and that was really reasonable. That's not what we're talking about. We're talking about reasonableness, the reasonableness in a legal sense. What is reasonable? So reasonable is what could an average person, a fictitious average person, what could that person conclude by either the appearance of a situation or the behavior in a certain situation? So again, for example, if I am flying a flag that has a marijuana leaf in front of my house, is it okay for me, or is it reasonable for other people in the neighborhood to assume that I like marijuana? Yes. Yes. Why would I have a flag in front of my house that portrays a certain practice if I don't participate in that practice? That's reasonableness. So keep that in mind when we read the Fourth Amendment. The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue upon probable cause. Supported by oath or affirmation, and the particularly describing the place to be searched and the persons or things to be seized. Again, probable cause. What is this idea of probable cause? It's related to reasonableness. Can we have a situation where the average person would not draw this conclusion? What is an unreasonable search? An unreasonable search would be something that the Nazis used to do, or something that totalitarian societies used to do, and that is they search your place every day, or they basically stay inside your house and watch your activities. Right? The Chinese are doing this right now with the COVID-19 surveillance, and this is actually a very becoming a very important issue in regards to public health. So reasonableness, what is reasonable, is changes from different generations in time, but also changes in different communities. What is reasonable? Students, when we're in class together in person, may ask questions about their situation, right? What is reasonable? Profiling is not reasonable. Profiling is illegal. So if I use data on a suspect's race or some other type of racial profiling, that is illegal. If I use data on someone's statistical averages, for example, 3 young men in a car tend to be involved in more crime than 3 old ladies in a car, that is not necessarily unreasonable. So with this use of big data, with this use of the surveillance information that states do have now, this idea of reasonableness is becoming more and more controversial. So what are some of the safeguards that a person can use? Well, I advocate never breaking the law, but there are some, this is a protection for you. It's not a get out of jail free card, but these civil liberties protect you from the overreach of the government. So there's something called the plain sight doctrine. The plain sight doctrine means that if the police see something in plain sight, they can use it. So what happens to a lot of people is that, and again, the police are trained and very, very effective in getting information from you. And a lot of people will either invite the police into their house and the police can see if there's any illegal activity, or you may have, like I said, the marijuana flag or a tattoo or something that portrays some kind of illegal activity and probable cause. The reasonableness, it would be reasonable for the officer to conclude that this was in plain sight and be used against you. So these ideas of the amendments are designed for you to get away with illegal activity is, again, a product of our popular culture and is not accurate at all. These amendments are designed in order to give the average person due process. Again, reasonable searches, Amendment 4. The famous Fifth Amendment. I have a brother who's an assistant district attorney, and he continues to tell me to tell your students to shut up, shut up, shut up. And what he means by that is that the police are trained, the police are very effective in getting information from you. They are not, everything you say to the police is not confidential. It's on the record. And the only protection you have is not to say anything. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of the war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor should be compelled in any criminal cases to be a witness against himself, nor deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So the Fifth Amendment talks in terms of this idea of being quiet. It also talks in terms, as related to the Third Amendment, it talks in terms of public use for private property. So just compensation. Again, this word just. So the state uses due process, usually a process of eminent domain. And let's say you have a house, and that house is, you've been living there for 30 years, and you're in California, and you're assessed a certain property tax, and that property tax does not go up. And every year you do your taxes, and again, these are just made up numbers, but let's say your house originally cost $100,000, and you continue to pay taxes on $100,000. 30 years later, your house is worth $1 million, and the government says, we want to build a new road. Your house happens to be on the cross of the pathway of the new road. We will give you $100,000. You say, wait a minute, my house is worth $1 million. Well, the government may say, well, the assessment that you've been signing your name to for the last 30 years has said that your house was worth $100,000. You never asked for a reassessment. You never asked that the value has changed. So we will use this original figure. Now, of course, you'd have to engage an attorney, and there'd be processes. But just compensation does not mean necessarily the fair market value. Just compensation means that the government, in the Fifth Amendment, you're obligated to receive compensation for when the government takes your property. Again, a protection that is not part of many other systems of government in the world today. The Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have the compulsory process for obtaining witnesses in his favor, and to have an assistance of counsel for his defense. Amendment 6 is what is known as due process. So when you are accused of a crime, you know who your accuser is. You have the resources to defend yourself. You can call witnesses. You can have counsel, right? Due process. So so if you look at the Fourth, Fifth, and Sixth Amendments, right? The Fourth, Fifth, and Sixth Amendments are designed to protect people from the encroachment or the state's using its criminal justice system to deprive people of their liberty. Doesn't mean, though, that it's going to protect you if you've committed a crime. What it means is that there is a procedural protection, right? The Fourth Amendment are searches. The Fifth Amendment is testimony. And the Sixth Amendment is basically the elements of the charges that of the police charging you with your crime or charging you with something, and those elements that ensure that you would get a fair defense. The Seventh Amendment. In suits of common law, where the value in the controversy shall exceed $20, it's more now, the right of a trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States than according to the rules of law. When we talk about courts and we talk about the law, we have to understand there's one sort of fundamental role that the jury plays and one fundamental role that the judge plays. The jury is the finder of fact. The jury is the finder of fact. The jury will deliberate, the jury will vote on if you were in the parking lot on the 22nd of July. The judge is the finder of law. Or the decider of law, right? You can only appeal on elements or efforts of the law. One cannot appeal on what the jury has found. And so you may be aware of the Innocence Project that goes on using DNA and other technologies that tries to prove people who are wrongly convicted. Those people don't get released automatically. What happens is there's usually a retrial or a mistrial based on an error of what the judge did. So to understand that, we have to start really understanding that distinction between the role of the juries and the role of the judge. And the Seventh Amendment is the one that sort of codifies that. The Eighth Amendment. Excessive bail should not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. How does one define cruel and unusual punishment? Again, we have that standard of reasonableness. What is reasonableness, right? The Ninth Amendment. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Again, the supremacy of popular sovereignty. The 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states respectively, or to the people. So, again, when we're talking about federalism, we're talking about this the state governments, which were in existence before the federal government existed. The 10th Amendment, though, has become sort of a legal truism. What I mean by that is the 10th Amendment, because of the dominance of the federal government, the 10th Amendment, there's not really an issue in which the states retain exclusivity over both the federal government or the people. Now, these liberties are used for individuals, but this idea, especially during the civil rights movement, this idea that the states could nullify acts of Congress or these other things are just wrong-headed and based on no legal principles at all. The 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by the citizen subjects of any foreign state. Again, it's an amendment that reforms sort of the Supreme Court's original jurisdiction. So those are the first 11 amendments. They constitute the Bill of Rights. When we talk in terms of the Bill of Rights, that's what we mean. We have this difference between civil liberties which says the government cannot get involved. The government cannot do something. It's a list of things that the government cannot get involved in, that the individual is protected from. Religion, press, speech, assembly, and petitioning the government in the First Amendment. Owning a firearm, the Second Amendment. Can't come and take my house, the Third Amendment. Can't give in unreasonable search or seizures, Fourth Amendment. can't torture me or force me to testify against myself, the Fifth Amendment. I get to know who my accuser is, and I get to have the resources to defend myself, the Sixth Amendment, and so on. These protections were designed to enhance the nature of the government and primarily to fight tyranny, to fight a dictatorship, to fight a king. Now, in 1804, they changed how we elect presidents because, unfortunately for John Adams and Thomas Jefferson, who both wanted to be president, we had a situation where the electors, so the number one person, the person after Washington leaves, right? George Washington is president, the first president, from 1787 to, right, 1800. So Washington is president 1789 to 1804. That's off. Anyway, forgive me. So Washington's president, right? Washington is elected unanimously in the Electoral College for his first two terms. Then you have a country that's split between the Federalists and the Anti-Federalists. During this time, Jefferson was the leader of the Anti-Federalists, and Adams, the sitting vice president, was the Federalist leader. The Electoral College came back, and the person who got the majority of the Electoral College was John Adams, and the person who was second was Thomas Jefferson. So you had basically the president from one party and the vice president from another party. Imagine Donald Trump winning the presidency and Hillary Clinton winning the vice presidency. And forgive me for the math of the dates, but you'll have to know dates for the exam. Amendment 12, the electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be the inhabitant of the same state with themselves. So again, the president has to be a different resident than the vice president. So that's the same. They shall name in their ballots the person voted for as president, and in distinct ballots for the person voted for as vice president. And they shall make the distinct list of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify and transmit sealed to the seal of government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be president, and such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest numbers, not exceeding 3 of the list of those who were voted for as president, the House of Representatives shall choose immediately by the ballot the president. But in choosing the president, the votes shall be taken by states, and the representation from each state having 1 vote. A quorum of this purpose shall consist of members of 2/3 of the states, and the majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever, the right of the choice shall devolve upon them. Before the 4th day of March, the next following, the vice president shall act as president. And in the case of the death or other constitutional disability of the president, the person having the greatest number of votes as vice president shall be the vice president. If such a number be a majority of the whole number of electors appointed, and if no person have a majority, then from 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole numbers shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible for that office of vice president of the United States. What does it mean? What did they do? Well, what they did was they basically changed it, because if you remember originally, when we read the second article of the Constitution, it says you vote for president, and the person who's number 2 on that list becomes vice president. So instead, all they did was say, okay, you got to vote for president, and you have to vote for vice president. That way, it's a distinction. That way, you don't have that historical fact or problem that we had with Adams and Jefferson. So we don't have, if you read the dates in your text, you have the last amendment, the 12th Amendment in 1804, and you don't have another amendment until after the Civil War in 1865. So again, a thumbnail sketch of American history. We have America, the United States, divided between North and South. The issue of slavery politically cannot be handled. So both branches of government, the legislative and the executive, turn to the Supreme Court and ask, what should we do? In the famous Dred Scott decision, probably the worst decision the Supreme Court has ever made. And basically, the Supreme Court said that the whole country will be slave. And this really accelerates a lot of the issues that under President Buchanan become the Civil War with the election of Abraham Lincoln. The war is the bloodiest war, as I said before, that we fought. And slavery has not been mentioned. Slavery has not been mentioned up until this point, has it? They've talked about 3/5 people. They've talked about people leaving and being called back, drawn back by the police powers, but no one ever says anything about being a slave until the 13th Amendment. And if you've seen the movie Lincoln, you know what kind of power was behind the importance of this amendment. So the 13th Amendment, Section 1, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Slavery is done. It's illegal. It's done. It's over. That's it. Slavery is in the ash heap of history. Now the question is, what do you do with the ex-slaves? And the next amendment, the 14th Amendment, and the 15th Amendment, two very important amendments, try to address this. The 14th Amendment. All persons born or naturalized in the United States and subject to jurisdiction thereof are citizens of the United States, of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed, but when the right to vote at any election for the choice of electors for the President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged except for the participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear the whole number of the male citizens 21 years of age in such state. The 3/5 is gone, right? 3/5 is gone. All this kind of junk of playing games around the representation of the House of Representatives is over. Section 3. No person shall be a senator or representative in Congress, or elector of president or vice president, or hold any office, civil or military, under the United States or under any state who having previously taken an oath as a member of Congress or as an officer of the United States or of a member of the state legislature or of an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. The Confederate officers, the Confederate legislators, the Confederate government, the people who swore allegiance to the Confederacy are out. Section 4. The validity of the public debt of the United States, authorized by law, including the debts incurred for payment of pensions, bounties for services in suppressing the insurrection or rebellion, shall not be questioned. We're not going to question the national debt. We honor it. But neither the United States nor any other state shall assume or pay any debt or obligation incurred in aid of the insurrection or rebellion against the United States, or in any claim for the loss of emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. So again, let's say you're Mississippi. You're the state of Mississippi, and you have all of these amputees from the Confederacy. You have all of this quote-unquote property that was lost to the war. You have an incredible state debt that you have to pay. No, you're not going to be able to pay that. That's illegal. That's null and void. We don't pay, the Americans don't pay for the insurrection. If you remember the history of the Revolutionary War, Hamilton, when the Articles of Confederation was replaced by the Constitution, and Hamilton was the first Secretary of the Treasury, the debt and obligation of the Revolutionary War was honored. That's because it's the same government. It's our government. The Confederacy was not our government. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. Amendment, the 15th Amendment. And I want you to take a note. 1868 of the 14th Amendment and 1870 of the 15th Amendment. These amendments are not fully enforced until 1964 and 1965, the Voting Rights Act. The 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Equal rights, right? The equal access to the voting booth. And Congress shall have the power to enforce this article by appropriate legislation. So I defined civil liberties as a government cannot do list. And we end this session today on an important idea of civil rights. All of us have the right to vote, according to the 15th Amendment. Yet, the African American community was denied that right to vote until the modern civil rights movement. And many argue in our society today that access to vote is still a controversy that certain public policies have retained against racial minorities, and the difference between in some states between rural communities and urban communities. Civil rights are the government must enforce. It's a government to-do list. Again, this question comes in, how do we make sure under the reasonableness, right, out of the work of our society, how can the government impose to make sure that everyone's civil rights are protected and are honored? So that is the big difference, and that is why civil liberties and civil rights are not interchangeable concepts, just like nation and state are not. So civil liberties are the government cannot do list. Civil rights are the government must do list. That takes us through the 15th Amendment. So we are at a point in the Constitution and in the amendments of the Constitution where I think you can see how we have protections of the individual from the state And now we're moving to preclude the state from enforcing slavery because, again, it did. The United States used its monopoly of coercive power, its sovereignty, to make sure that slavery was enforced. And this is a unique aspect of the African American community, that they are the only community that has been enslaved by the government, where many other communities have been discriminated against. But the outlawing of slavery and to make sure that people have access to the voting booth comes out of the drama, comes out of the tragedy of both slavery and the Civil War. Next time we're going to continue with and concluding of the Constitution of the United States. I'll see you then.